Madam, hello. Madam, I am Murli Prasad again, IIT Kanpur. Madam,
Yes, sir, there is some problem. Sir is communicating with me on the mail. Hello?
Ma'am, Schäfer sir is here.
Yes. आ गए अभी ना वो ऐसे बंद करके आ जाए
सर मैं एक कॉन्फ्रेंस में हूँ सर। मैं 10 मिनट में
Hello?
Hello. Yes, sir. Welcome, sir.
वेलकम सर
Hello, welcome. So there were some problems, but it seems that I have now managed. I want to upload something. Is that possible?
Yes, sir. So on the top left of your screen, you can see a tab saying share. So could you find it?
It takes a minute. Oh. These are not my... Oh my God. These are not my ordinary... So is it uploaded now?
नॉट येट
No,
सर
sir. Not yet, sir.
So I must try again.
यस सर इट इज
Sir,
विजिबल
we can see your screen, sir. So you can open the presentation now. So we'll be able to see it.
Do you see it?
यस सर यस सर इट्स विजिबल नाउ
Is it visible?
यस
Yes,
सर
sir.
Okay, then I can start. Well, thank you. We are a little bit late due to technical problems, but I'm glad that it works out and I want to greet you. I assume I cannot see the participant. Is that correct?
यस सर
So can you tell me a little bit about the audience before I start?
श्योर सर it is a combination of students practitioners and lawyers and advocates along with researchers and some professors as well sir
Yeah. Thank you. Thank you for inviting me.
sir, I would, if I could have the great honor of introducing you, sir. A very
Sure.
short
Yeah.
introduction,
Okay.
sir. Thank you so much, sir, for taking time out to address this audience and for accepting our invitation. It is my absolute greatest honor and privilege to introduce our distinguished plenary speaker of the day, Professor Bernd Schäfer. Professor Schäfer is an economist and a pioneer in the field of law and economics in Europe and around the world. He is Professor Emeritus at the University of Hamburg and the former director of the Institute of Law and Economics. Currently, he is an affiliate professor at Bucerius Law School in Hamburg, Germany. He has been a visiting professor at various universities abroad, including the University of Toronto Faculty of Law, the distinguished visiting professor at the University Faculty of Law at George Mason University, and the Indira Gandhi Institute of Development Research. There is just a slight change in the topic, and Professor Schäfer will now be taking the session on the topic of rules and standards of law. Sir, it is really an absolute great honor to hear you and to hear and listen to a legend like you. And I request Professor Dr. Anita Nagar ma'am, if you could kindly deliver the brief opening remarks for the plenary session. Thank you so much, sir.
Thank you. Thank you.
Good evening, Professor.
Good evening, Anita.
How are you, sir? You're well?
Yeah, okay.
Yes. So I cannot miss this opportunity to not talk about Professor Schäfer's contribution to the law and economics domain of India. Professor Schäfer, Prasad sir is also with us, and I think Ram Singh sir will also be joining us. His association, Professor Schäfer's association with India has been over 20 years. It must be more than that. He was instrumental in making the RBI chair for law and economics at IGDR Mumbai, where he worked very, very closely with the former governor of Reserve Bank of India, Dr. Y.V. Reddy, a person that, you know, we hold in great credit for the very stable banking system that then and those days can boast of. Professor Schäfer very, very proactively, with a lot of enthusiasm and strength, made collaborations with the University of Hamburg and a number of Indian universities within the program of the Erasmus Mundus European Masters and Doctoral programs in law and economics. A collaboration and an association which has helped contribute tremendously to the to those who are today known as the national scholars and experts in the area of law and economics. Some of them are with us today, including Professor Prasad and Professor Ram Singh. His association with Gujarat National Law University started just a little before 2015. That was the year in which we initiated our international conference on law and economics, which started initially as a consortium between the IIM Ahmedabad, IIT Kanpur, and Gujarat National Law University. Sir was present in our conference in 2015. Those were the times of swine flu also. So that adds an added dimension to the pain that he took to be with us. And that was the first of his conferences. And now we have 5 such annual conferences down the line. More importantly, in order to concretize the foundations of law and economics, Schäfer sir guided us, encouraged us to form what is known as the Indian Association of Law and Economics, which has been formed for the last 4 years. We have the Indian Association of Law and Economics with a very, very large number of members, faculties both from law and economics and practitioners. And Professor Schäfer, all this is to say that clearly we see an increasing amount of maturity and interest in the in now a recognized area of law and economics in India, and we have a huge amount to credit you for this. And I will stop right here because everybody is so interested in your session. But that has been Professor Schäfer's contribution to law and economics in India more than a span of 30 decades. Over to you, Professor.
Thank you, Professor Nagar. Thank you for the invitation. Thank you for the very kind and nice words. And thank you for mentioning that there are some good friends in the audience. So with Ram Singh, I have a very intense cooperation, and we are in the process of writing something together. Probably only next year we can meet due to Corona. I also greet Professor Prasad, whom we know each other for many decades. My topic today is the debate on legal rules and legal standards. And I assume that not all of you have heard about this debate, and therefore I want to say what rules and standards in this debate mean. Rules are very precise legal norms. For instance, a rule in this debate is a speed limit. Let's say a speed limit in a residential area of 20 miles per hour, for instance. That would be a legal rule. So a legal rule is crystal clear, precise, and we know exactly what it means. It is a clear legal command, and we know exactly how to handle it. We know as citizens, we know what it means, but also the policemen, the judges, and the public administrators know exactly what when a rule is violated. A standard, on the other hand, is something imprecise. It is, it is open-ended. For instance, the term negligent is a standard. And negligent, as you all know, plays a very important role in the in civil law, in the private law, in the law of contracts, in the law of torts. Very often a damage claim depends on the negligence of a tortfeasor, but it is an open-ended concept. One can discuss it, very lengthy. Or, for instance, a standard is also reasonable behavior. Sometimes a damage claim might depend on reasonable behavior. So we have the law meanders between these two concepts, between crystal clear and vague concepts. And there is now a debate on under what conditions should the legal system prefer clear rules, and when is it better to have standards? And I want to give you, to start my talk, with an example from European history. It's not a very, let's say, it's not a very important example, but it makes clear what the relative merits of standards and rules are. Now, if we go back in history, let's say 250 years, then we have in Europe, as everywhere in the world, there is no difference between cultures. It is everywhere in the world, the parents decide on the names of their children. It's the parents who decide. And in Germany, the parents can give their child any name they wish, with one exception, with only one exception. the name which the parents choose must not violate the well-being of the child. So that is the legal rule. Parents can pick any name, but it must not violate the well-being of the child. So if, for instance, and that has actually happened, the parents name their child Devil, then the registration officer will not accept this name. He said, you can tell anything, but not Devil is not allowed. That because that violates the well-being of the child. And we had once, but to take the registration officer to take a good and informed and learned decision on this must have some competence. He cannot, this is not a schematic decision. It is something for which you have to have some expertise, some knowledge, some psychological knowledge, and so on. So we had, for instance, a couple of years ago, there was a lady, she was from Munich. She went to France in holiday, and when she came back, she was pregnant, and she gave birth to a child, and she named this child Souvenir. And that it was now for the registration officer to decide whether that name Souvenir is against the well-being of the child. Now the registration officers thought a while, and then he accepted the name. And then 2 years later, the same woman went to holiday again. She came back again, pregnant, gave birth to a child, and she named that child Souvenir 2, second souvenir, so to speak. And this time, the registration officer did not accept it. And he said that is against the well-being of the child. And from this, you see that you have, on this position as registration officer, you have to have somebody who has some expertise, some training, some knowledge about what is good for a child. Now, when we go back 250 years, then we had a totally different rule in Germany. Namely, we had the same, the principal legal rule was exactly the same, but parents could not pick any name they liked with the confinement that it does not violate the well-being of the child, but they had to pick a name from a closed list. So there was a government commission at the time, and there were experts on names and so on, and they drew up a long list, and the parents had to pick one name from this list. Now you can see it is intuitively clear what the shortcoming of the one and the other rule are. The first rule, where parents can pick the name of the child, and the restriction is only that it does not violate the well-being, which is a very, very vague standard, has the disadvantage that it is difficult and it needs some expertise, or we economists, we used to say, you need some human capital here, some training, some investment into the skills of this registration officer, that he can take a good decision. Whereas 250 years ago, the registration officer did not need any skills. The only thing he must know is to have some knowledge. He must be able to write a little bit, to write at least a name into the register, and to read, and to check whether the name which the parents wanted is on the list. And that is, of course, a level of knowledge which is much, much lower than the level of knowledge which the registration officer must have today. So this is, you see here, this clear legal command, you must take a name from the list, has the advantage that the exercise, the enforcement of this legal norm is very simple, very cheap also. And you can also see what the shortcoming of this 250-year-old rule is, namely, it is not flexible enough. Now, assume, for instance, that things change, the tastes change, or we have immigrants in a country, and the immigrants might prefer names which are not on that list. Then, you have a discrimination of some people. So you have here flexibility on the one hand, and not enough flexibility for the one rule, but the rule can be administrated easier. So now I give you some more examples here, and what it means that when we talk about rules, rules are precise. The speed limit and decision based on rules are known to those who are dependent on the law, the citizen, the judges, administrators. They know exactly ex ante what the rule means. And the rules also allow for more or less mechanical and syllogistic decisions of civil servants and judges. And a rule is never very information intensive. For standards, to adjudicate a standard, a court or a civil, let's say a regulatory agency must collect a lot of information. So you need often much information to adjudicate a standard, but a rule is not information intensive. Also, as I told you before, for legal rules, you do not, the persons, the civil servants or the judges do not need much expertise or training for their decision making because it is clear. And rules to be benevolent or to be beneficial to the people they imply a high level of legal certainty. So if we want legal certainty, if we want to know exactly what the law is, then we should go for rules, not for standards. But that is also now a downside of the rule. The rule can be sticky, might not be up to date, might be out of touch. So if you have a legal system which is mainly based on crystal clear and precise rules, then the downside of such a system is, of course, Parliament or the government, they must update the rules very often, very quickly. And if they don't do it, and then if the economic environment changes, or if the custom changes, or if morals change, if the society change, then the rules might become sticky, and then you take the totally wrong decision, or people might simply not observe the law anymore because it does not serve them. Now, negligence are vague. I told you already, negligence, legal standards are vague. Negligence is a legal standard. A fiduciary duty, for instance, in company law is a legal standard. The business judgment rule for managers, to sort out what is still in the interest of the company and what is not in the interest of the company. Business judgment rule, which plays a big role in American corporation law, is a legal standard. And for that to adjudicate this, you need judges who are very well trained. And decisions are often not well known ex ante. You know, when somebody plans, then does not know exactly whether he violates the law or not. And standards are often mission oriented, well-being of a child, or animal welfare, or welfare. Or for instance, for the central bank, we have the mission of price stability and high level of employment, for instance. And legal standards are information intensive. That is, judges and civil service, people working in the regulatory agencies, they have to collect a lot of information. It takes a lot of time and money to get the information which you need to make a good decision on the basis of a standard. Also, legal standards require for the person who takes decision on the basis of standard subtle reasoning. He must know, for instance, if it is mission oriented, he must know the mission, and he must know whether his decision is something which brings the situation closer to this mission. They require high levels of training, so you have to have people with a university degree who know the things they are dealing with and so on. So it is very complicated, and you need, so to speak, a lot of human capital in the civil service for running it on legal standards. And now that is also a very important point. If a legal system is characterized more by legal standards rather than by rules, this requires a high level of loyalty to the law of judges and civil service, because they are given discretion. They can, the law does not tell them exactly what to do, but it tells them to do something reasonable, and then they have discretion, and then a system which is running on standards must have judges and civil servants who do not cater their own private ideas of what is just or what is good, or might even be their private, they might be corrupt, they do something for themselves. So you have to have a low level of corruption, a high level of loyalty to the law, if you run a legal system more on standards rather than on rules. Now, I want to say something. This dichotomy between rules and standards has also been questioned, and it has been argued that rules are not algorithms. They are subject to interpretation and not precise. So I give you an example of a speed limit in Germany, for instance. Now, we had a speed limit, usually within cities, we have a speed limit of 50 kilometers. And it is quite clear that if you speed, then you get a ticket, you pay a certain amount of money, and the amount which you have to pay depends on how much more than the allowed 50 kilometers the driver drove. So that is clear. You could say this is a clear rule. But it is, of course, not clear, because we had several cases in which people speeded, and the court decided that they were correct in speeding. So there was one case, for instance, in which a man brought his wife who was in labor to the hospital where she gave birth to a child, and he had to drive her to the hospital, and he speeded. And then he did not pay the ticket. He said that was necessary, and the Supreme Court decided that he was right. So, you know, even in this seemingly very clear case, the case is not 100% clear. And there was another one also, car speeding, because they wanted to inform the driver of the lorry that that there was something, a problem with a tire, with one tire. It was not fixed correctly, and they speeded to warn him, and that might have saved his life. And again, the Supreme Court decided that this was not, that he had the right to speed. But then in another case, there was somebody who speeded because his dog had to be brought to the dentist because he was hit in an accident. And in that case, the court decided that this was not, that this was no sufficient reason not to observe this rule. So we have, you know, if you are very, you know, if you look at even the most clear rules more precisely, then you learn that even precise rules are not precise. But I would say this is clear, but it does not question the basic dichotomy between rules and standards. So then Samir and Teichmann have written quite an interesting paper. They say that if you have rules, if the whole system runs on rules, then you might have, then the probability that you have conflicting and contradicting rules increases. And then instead of legal clarity, you get some legal chaos. And that has been investigated by several scholars. In Russia, in the 19th century, in 19th century Russia, that was exactly the situation, that the Tsar wanted clear rules because he did not want to give too much discretion to his judges and to the administration. But he couldn't manage it because the rules then some very often contradicted, and that was unavoidable. And then the whole system became dysfunctional. Also, what has to be said here is that rules and standards are are not in total opposition to each other, because many standards develop into rules over time. So, for instance, if you have this concept of negligence, then by the courts, it is for the courts to decide what negligence is, and then over time you have an accumulation of many different court decisions, and these decisions are then related to categories of accidents, for instance, and then after some time you know exactly what you have to do when you drive a car or a bicycle or a motorcycle, or what you have to do as a cyclist, or if you walk. Over time, this negligence principle is made clearer and clearer and clearer by way of jurisdiction. But even that does not destroy this distinction. Now, I want to concentrate now on some economic aspects here. Now, it is clear that if you compare rules and standards, then rules and standards economize on different aspects or on different types of costs of the legal system. And here I concentrate on two types. The first type is the cost of rule specification, and the second type is the cost of rule adjudication. Now, it is clear that to make a good rule, make a very good, precise rule, you have to, the cost of rule specification are relatively high. So to have a very comprehensive book with all the names of all names of all children, you have to assemble a lot of experts who write this down. So the costs are high. At least they are much, much higher than a rule which says the parents do this with some limitation, that is the child's welfare. So the cost of rule specification are relatively high, but the cost of rule adjudication or of observing the law or of administrating the law are low, because administrating and adjudication is not information intensive. It is simplistic and almost automatic. And therefore, you have here this feature. Now here we have at the vertical axis, we have the court costs, and we have the number of cases in a particular legal sphere on the horizontal axis. And you see the marginal costs of a standard are relatively high, and the total cost of standards are steeper. The cost curve is steeper than for rules. And then what you can see is that if you have legal problems which occur very often, if you have a large number of cases, then this difference in these total costs lead to a situation in which, with a large number of cases, the total cost of having a rule become lower than the total cost of having a standard. So that is, for instance, that explains to some extent that in the field of car traffic, motor vehicle accidents, and so on, we have lots of rules which are very precise, whereas in some other cases where we have few cases, the cost of rule specification would be too high. So we have then a standard and leave it to the courts and to the judges to decide. Now, rules are less costly to adjudicate, and that is something which is important for an informed judgment about what to prefer. Now, the costs of resolution and adjudication are usually paid by private parties. So if you go to court, then most of the court costs, but also especially the cost for witnesses, for the lawyers, have to be paid by the parties. So if you have rules, these costs are relatively small. And if you have standards, these rules are relatively high. And the cost of norm specification is usually paid by the state, that is by the taxpayer, whereas the cost of conflict resolution is paid by private parties. So if you relate this to low-income countries or to countries with insufficient legal aid, then of course it helps low-income parties. A system which is based on rules is better for low-income parties than for high-income parties, and therefore you would expect more rules in a low-income country, especially if you want to help people with low income to get access to court. Also, if legal rules, that is discussed this with the Israeli guy Uri Weiss, who wrote a paper on that, if legal rules lead to more legal uncertainty, that is not necessarily so, but it can be that they are clearer, more legal certainty. They are more valuable for societies in which people are relatively risk averse. So risk averse people prefer more certainty, and they would also prefer more rules. And less risk averse persons would trade off some of this certainty if they gain flexibility, for instance. So that also plays a role when we make up our minds what is better. Also, rules are superior to standards if the quota of well-trained civil servants and judges is low. Now, I have written a couple of years ago a paper on this. Michael Four has also worked on this. Now, assume you have a country in which the number of very well-trained lawyers is relatively low, and the number of badly trained civil servants is relatively high. And economically speaking, you could say that the amount of human capital which you have in this in the system, in the civil service system, that this amount of human capital is concentrated on relatively few people, whereas in a rich country you might have more human capital in more investment into training and schooling and university training than in a low-income country. Then one can argue that it is better for a low-income country to concentrate these very well-trained people for diligent rule making, that is for making good rules which then people with lower training can adjudicate. They need not much training to adjudicate the rule, but to make a good rule you need a lot of training. So it is then possible, if a country has a low level of human capital, to concentrate the human capital in rule making rather than in rule adjudicating. And then if you leave the adjudication to the less trained people, then it is better to have clear and precise legal norms, that is rules. Because adjudication of vague standards leads to many errors if you have not well-trained people to take these decisions. Also, then the decisions are simpler, relatively cheap, and they are not information. To take a good decision, you don't need to collect a lot of information. So you save cost at this level and make norms more clear. I give you an example. I had once Kragman, perhaps Kragman is a professor for corporation law at Yale University, and he was once in Hamburg, and that was shortly, he visited our PhD program in Hamburg, and he told me that after the Russian revolution, after the the collapse of communism in Russia, in 1993 or 4, he was in Russia, and he drafted the Russian corporation law. He said, they asked us to write the Russian corporation law, and he said that this was not very much politicized. So he said we made a draft and we submitted it to the Duma, the Russian parliament, and it went through. And now he said that he was very much aware of this problem of rules and standards when he drafted the Russian corporation law. So, for instance, he said that at the time, the Russian judges they did not know what a company is, what a stock-listed company is, and what kind of problems they have, because they had got their training in the Soviet period. They said these judges don't know anything, so you must have very clear and precise norms in the law. And I give you only one example. One big problem in any corporation, and of course also in Russian corporation, is that the management works in its own interest, not in the interest of its shareholders, but in its own interest, and tries to, lead the money into their own coffers. That is a big problem, and there are many legal norms to check with this. And in the United States, you have this business judgment norm. That is, a manager can basically do what he wants, but he must show to the court, when that leads to a court case, must show to the court that that was in the limits of the business judgment rule. And he said, of course, we could not, Kragman now said, when we drafted the Russian code, we could not do that. We had to think of something else. And then, because the judges, these judges with little training of what the problems in a company are, they cannot make this, they cannot adjudicate a business judgment rule. Perhaps in 20 years or 30 years, that might be possible, but not at the time. And then he said, we inserted, therefore, a crystal clear rule that one member of the management team must be elected with supermajority, I think 90% or something, I don't remember, but with a supermajority, not with simple majority, but with supermajority. And the underlying idea behind it was that if one manager in the management board is elected with, say, 90%, then it is clear that at least one member of the management board has the support and the trust of the minority shareholders. And the minority shareholders have at least one in the inner circle who knows exactly what is going on there. And he can, when the other managers do something in their own interest, which he can inform the public, or he can inform the minority shareholders. That is an example how this dichotomy works in different countries, and what might be good in the United States. The business judgment rule is not good in in Russia, and what might be good in Russia, this might, at least one member of the management board is elected by the minority shareholders. That might not good for the United States. Also, for countries where corruption of judges is a big problem, it is better to have or corruption, disloyalty in general. It is better to have clear rules, because an outside observer, let's say a newspaper reporter or a member of some civil society group can much easier observe whether let's say, a judge sticks to the law or whether he violates the law. For instance, take again this example of the business judgment rule. For the business judgment rule, you have the judge has to collect a lot of information. He must make very elaborate and difficult arguments, and then an outside observer cannot really see whether these arguments are correct or whether he just hides his corrupt decision behind subtle arguments. But if it is very clear, then he cannot do this, because, for instance, if there is a management board, and when one member of the management board was not elected with 90%, and the judge let this pass through, then it is clear for any outside observer that he had broken and violated the law. And then you can campaign against him. So it is much easier to observe corrupt or disloyal behavior. And that strengthens, of course, the fight against corruption. Now I have here, I once, a couple of years ago, I gave a talk when I just wrote this article, and I came about a citation from Plato, the Greek philosopher Plato, who lived 400 BC, and he wrote a book on the laws. And I was really surprised what he wrote here. He had already understood this. So the question which he discussed with his disciples was, should a judge decide himself about a damage compensation, or should there be a fixed formula for damage compensation? Let's say, for instance, in the ancient times, I don't know how it was in India, but I presume that it was similar in India, but in many European countries, including Greece, but also including Persia, which is not European, there were very clear rules with regard to damage compensation. For instance, if in the Codex Hammurabi, there was a rule that if somebody killed a slave, then the damage compensation was so and so much silver. And otherwise, if it was not a slave but a freeman, it was gold, so and so much gold. So that it was this kind of thinking, and so the judge had not the discretion to decide on the damage compensation. And about this point, Plato discussed with his disciples, and that was the question. And he said, I may reply that in a state in which the courts are bad and mute, then there is a very serious evil which affects the whole state. If the state for which the judge is legislating be of this character, he must take most matters in his own hands and speak distinctly, the lawmaker. But when a state has good courts and the judges are well trained and scrupulously tested, the determination of penalties or punishment may fairly and with advantage left to them. So now I come to my last point. The division between rules and standards also has a very important impact on the distribution of state power. Now, if you have, let us first take private law. That in private law, contracts, torts, property, intellectual property, bankruptcy, corporation. That is private law. And if a legal system moves from rules to standard, then this is inevitably associated with a delegation of power from the government and from the parliament to the judiciary. The judiciary gets more power, parliament has less power. If that is not the case, so if the legal system is based on strict rules, then the power is concentrated at the state. And it is quite interesting that I give you only one example here about what this means. In Tsarist Russia, also before World War I, Russia had imported much of West European, including German contract law. So the Russian contract law was built, was not a copy, but was influenced by German and Swiss law, contract law. But in German contract law, we have one very prominent standard that is the good faith principle. I cannot go into the details here, but the good faith principle gives the judge a very discrete possibility to deviate from the black letter law if the situation is otherwise, if black letter law would lead to unbearable decisions. So the judges making use of the good faith principle have a wide discretion in contract law. And the Tsar, who imported the contract law from the West, however, did not import the good faith principle because he did not want to give so much power to the judges. However, when it comes to public law, that is administrative law and regulatory law, then the situation is exactly different. So if you have laws in which let's say an agency is dependent on rules, then the citizen knows exactly what the agency can do and what it cannot do. And if it is, however, based on standards, the agency has much more power, and the citizen does not know how much power the agency has. Therefore, I give you just an example how that is used. Now, here we have some countries in which in which the government is taking in which the government can decide on a taking, and that is in India you call it land acquisition. You know, the eminent domain power, the eminent domain powers. So the eminent domain, the state has eminent domain powers, and in some countries, these eminent domain powers are based on very vague standards. For instance, in the United States, I couldn't believe that when I read it. I have written a paper with Ram Singh on this. In the United States, it is possible to base a taking decision on the very general concept of economic development. You know, economic development is a good thing. What it exactly means, that is a very unclear thing. This is the situation in the United States. In Germany, that would be totally impossible. That would be unconstitutional. So if a state would say, so your taking decision is we take your land and we base it on economic development, whatever that means, that would be unconstitutional. The whole taking decision would be unconstitutional because it is too vague. So taking decisions in Germany have to be based on laws which are rules. So they can, for instance, if you write in the law, for taking is possible for road construction, that is precise enough, or for public traffic, for public airport, for a public airport, that is precise enough, but not for economic development. And I have read that in South Africa, even a taking is possible, or for a social purpose. Social purpose is, so that means or implies that the government can take land for what almost every purpose it wants. And therefore, if we want to curb willfulness of the government, then rules are good for doing this. And we in Germany, we have a constitutional principle which extends to not only to taking, but it's a general principle that a law which entitles the government to do something against the citizen, to take a decision against a citizen, that this norm must be clear. We call it legal clarity and proportional. Norm and Clyde is the German. Otherwise, it is unconstitutional. So the interesting thing is that if you have rules for the administrative law, then you curb the power of government. And if you have rules, if you have standards for the rules of civil law, you also curb the power of government and shift some of the competencies to the judges. Now, let me come to the end. I want to just to clarify on one point and one thing which I think is very important. I think that in the course of economic development, we get better trained judges. We get better, highly educated judges and civil servants, and we also get less corruption. There is, corruption is a problem in all countries, but it disappears to some extent, to a larger extent, with economic development. So the high income countries are usually, the civil servant is much less corrupt. And both these things, that you have less corruption in the public system and more training and better, better abilities of decision makers, these two things together explain why when a country becomes richer, moves from a low-income country to a high-income country, there is also a tendency in civil law, I mean in contract law, tort law, and so on, that the very precise rules are replaced by standards. So let the judges decide, let the people who are at the problem decide, not a general decision. And but also when countries move to a let's say rule of law state in which discrete and willful decision of the government are effectively checked, and the government is made responsive and responsible, then at least if you entitle the government to take decision against the citizens, which is always necessary often, but then to formulate these rules which entitle the government with as much legal clarity as possible. That is the legal clarity. And then if you have a constitutional Supreme Court, the court could even then otherwise decide and rule that this entitlement is not based on clear enough norms. So thank you very much. Hello?
Yes, sir. Professor
Yeah.
Schäfer, thank you so much for the session. There are a couple of questions if
Sure.
you could answer them, sir. Amit, Piyush is asking if the persons who are entrusted in the task of making rules or regulations are self-interested and are interested in aggrandizing their own power, then how can these rules be beneficial for poor countries? And the problem might be aggravated if they have low human capital.
Yeah, yes, that is, thank you. That's a very good question. And I have not elaborated on this problem too much. Of course, if you have clear rule specifications, then they can be misused. Rules can be misused to cater the interest of small groups and so on. That is clear. That is a disadvantage of rules. For instance, I gave you this example of the names. Today parents, they decide on the names of their children, but 200 years ago, it was not possible for a Muslim, for instance, or let's say an Indian who lived in Germany. There were not many, but some were there. They would have to name their child Fritz or Hans or something, but not an Indian name because it was not on the list. And that was deliberately perhaps so. So I see this point very clear, but still that does not question the fact that in in a country, for instance, in Russia, where I come back to this example, where the judges have no expertise on how a modern company runs, that company law should be more rule-based rather than based on standards and the expertise, and rely on the expertise of the judiciary.
Right. Thank you so much, sir. Amit, a second question Amit is asking, would it be better to leave a law ambiguous and broad, or would it be better for a set of specific norms to be laid down, as whether laws should be left to the courts to interpret?
I'm not sure whether I fully understood the question. So if the court, can you repeat this question, the first
Yes,
part of it?
definitely. Yes. Would it be better to leave a law ambiguous and broad, or would it be better for a set of specific norms laid down?
Yeah, well, one cannot say that one is better than the other, because, for instance, as I said, it is good to have rules when we have situations which occur very, very often. Then it is better to economize on the costs of rule application by a civil servant rather than on the rule specification, because these fixed costs of rule specification, they are then, they diffuse on many cases and are very small. So a general answer to this question is not possible. I have only tried to specify some conditions under which rules might be better than standards or the other way around.
Thank you.
Uh,
Thank you so
so
much, sir.
I have a question, sir. So, are there any studies which show a general trend? Maybe it could be region-wise or worldwide towards standards versus rules.
Yeah, well, yes, there is a trend. You know, we have there are empirical investigations on constitutions. You know, and we have countries with a very short constitution. And these are usually countries which are not democratic and which are very homogeneous. So the country with the shortest constitution in the world is Tunisia, Tunisia in Northern Africa, which, you know, there are only Muslims living there and only from the same tribe or from the same ethnic origin. So that is relatively easy. And the longest constitution in the world is in India. The USA have, and in India, if you ask what makes the Indian constitution so long, then the answer is that in India, India is a very diverse country. You have many ethnicities, you have many religions, you have many cultures, you know, everything is very diverse. And therefore, to compromise between all these different groups, one had to lay down it in the constitution in a very detailed way. And that, according to my colleague Vogt, who is a colleague in Hamburg and has worked on this, and he said this explains why India has the longest constitution. Well, I think with 146,000 words, whereas the German constitution is shorter. It has 20,000 words. And if you take the number of words of a constitution as an indicator of how precise the legal norms are, then the Indian legal system, the constitution, consists more of rules rather than standards. Whereas, for instance, in the United States Constitution has only 6,000 words. It is one of the shortest constitutions. And again, the explanation for that is that when the Constitution was written, America was very, let's say, homogeneous country, and therefore they could base it on standards rather than on rules. But if that is not the case, and if there is a lower level, necessarily lower level of trust between the between the citizens, then they write it down very precisely. And that is a general feature, I think. Also, a general feature is that if a country moves from low income to high income, then the civil law becomes more standard based rather than rule based.
Thank you, Professor.
Mm-hmm.
Thank you so much, sir. We have one more question, if you could answer. Sir, Adrika is asking, having rules in a legal system has its own benefits over standards in both low and high income countries. But don't you think this will actually encroach on the process of judicial activism?
Yeah, this is clear. A legal system which is based on rules gives less leeway to judges, also to Supreme Court judges. So it is more, as I told you, with imprecise rules, with imprecise standards, the political system shifts power to the courts, also to the Supreme Court. And that gives more leeway to judicial activism. And judicial activism can be a good thing. It must not be a good thing, but it can be good. For instance, in Europe, the European Court of Justice is a very active court and has moved Europe more to the, let's say, to unity, to more unity, more than what national governments could have achieved, probably. So it is, but that would be another lecture. But in general, one can say, yes, if you have more standards, then you have more judicial, you have a bigger role for the court. That is quite clear.
Thank you so much, sir. Professor Ram Singh, sir, if would like to speak a few words. Sir.
Oh, thank you. Yeah.
Actually, I have a question for Bernard. May I ask it?
Sure. Hello, Ram. How are you?
Hello, Bernard. Good. Listening to your talk, even though I could attend only the latter half of your talk, I could not connect in time. But my question is about good faith principle and its dominance in German law. It is not a dominant principle in common law countries.
Yes.
Even though many of common law advanced in terms of economic development and legal evolution as German law. So how do you explain in the context of rules versus how do you explain its prevalence in German law and its absence in common law countries?
Yeah, thank you, Ram. That's a very, very interesting question, and I I think I can answer it. The good faith principle is a principle of contract law, and in Germany, contract law is more caring about the people, about the parties. It cares more than, let's say, in England. In the United States, they have also imported the good faith principle from Germany, more or less, but it has no tradition there. But it is part of the American contract law. But the British, they reject this. And they say the philosophy of the British lawyers is we do not want to impose to the parties questions of fairness. We look at the contract and we say what have the parties stipulated in the contract, that is it, and we do not want to go much beyond this. And in Germany, the legal system is more, it goes more into interpretation. So I give you one example where perhaps, I'm not sure, but probably English courts would take a different decisions. We had the following case. There were two medical doctors. One medical doctor was in Hamburg, the other was in Munich. And the medical doctor in Hamburg wanted for private reasons to move to Munich and the Munich doctor to Hamburg. So they made a contract to swap their practice. So the medical doctor went from Hamburg, got the practice of the doctor of Munich and vice versa. So that was the contract. Now this happened after a couple of months. The Hamburg doctor who went to Munich, the personal reason to go to Munich did not exist anymore. So I don't know why. So he came back to Hamburg only after a couple of months, and he opened up a practice in the immediate vicinity of his old practice, of course, with the idea in mind that the patients would come to him and not to the other doctor. So this doctor from Munich who came to Hamburg, he wanted, he went to court, and at the end of the day, it went up to the Supreme Court, and the Supreme Court ruled that to open a practice in the immediate vicinity of the practice which he had before sold violated the good faith, and that he was not allowed to run a practice in the immediate vicinity. Not in Hamburg, he could do it, but not in the immediate vicinity. So they imposed to him a non-compete clause by using the principle of good faith. So that was the German rule. I discussed this with a former PhD student who is now professor of contract law in England. I asked him, so how is that in your country? And he said, well, you can never be sure. But he said, with 75% probability, he said, an English court would not do this. They would not impose it. They would tell to the parties, if you didn't want to compete, then you could have written it, you could have stipulated this in the contract. Why didn't you do that? And if you didn't do it, then, then it is not our business to extend the contract. That is the difference, I think, between common law countries and civil law countries in general. And there is something to it which is good, I think. But in Germany, in general, contracts are much shorter than in England. There is a gossip. It's not, I have no empirical data, but a gossip from Hamburg lawyers. They say that a contract which is 6 pages in Hamburg is 60 pages in London, the same contract, and 600 pages in New York. So what you do then, if you make a contract in a common law country, you go, you have to think of all possibilities and of all contingencies and write it all into the contract. And therefore, in the United States and England, contracts are much larger, much longer, and therefore more precise than in Germany. In Germany, you can write short contracts, and you can trust on the courts that, and the legal rules, that they will adapt it to new circumstances. And, I had exactly this discussion with a group of English students 2 years ago. I gave a class in London. They asked me the same question. And I said, if I were a CEO, let's say, or a manager of a very large company, I would prefer English law, because English law takes more serious what I want. And if I make, let's say, big transactions in the millions and the billions and so on, then I can specify a fully specified contract. But I said, if I were the manager of a small company, I would prefer the German law, because the German law is more caring and you can economize on the costs of writing, of making the contract. The transaction costs are lower.
Yeah, thank you, Bernard. This is very illuminating.
Thank you, and have a good day.
You too.
Thank you so much, Professor Schäfer, for an eye-opening session with profound and deep analysis, rules and standards in law. And thank you further for taking time out to answer the questions in a very detailed manner, and to listen to you and to hear your lecture and to interact with you, I think was truly a great experience. And sir, we at the Center for Law and Economics are truly grateful to you for your steadfast support, constant motivation and encouragement to us, which has, I think, ultimately culminated in this academy. Sir, I am Anant Agarwal. I'm a student at GNLU, and I'm currently studying your seminal book on the economic analysis of civil law. And it was truly an honor to hear you, sir. We thank you so much for taking time out for addressing the audience. And may I now request Professor Dr. Anita Nagar, ma'am, to kindly deliver the closing remarks for the plenary session. Thank you so much, Professor Schäfer.
Professor Schäfer, just a very big thank you, and please take care of yourself.
Thank you. Thank you. And all the best, and have a good evening all together. Bye-bye.
Bye, sir.
Thank you so much, sir.